We're here this morning for one video oral argument, which is Donna Gustinski versus Pleasant View Health Care Center. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you are the appellant and are reserving time, if you could let me know when you get started. I'm keeping track of time. Please don't use the name of any minors or victims during oral argument. I don't think it's a problem necessarily with this case, but we are streaming live as well as recording and placing this oral argument on our YouTube channel. If you are not arguing, if you wouldn't mind muting your microphone just so that we don't have any background noise. We have read the briefs and we are ready to proceed when you are.
All right. My name is Gary Makowski. I represent the plaintiff appellant in this case. Believes the court, Marion Gustinski was admitted to Pleasant View Health Center on September 9th. She was discharged on October 28th. Previous to that, she was admitted to Akron General Medical Center from September 1st through September 9th. During that admission, she had a decubitus ulcer on her coccyx area, which developed at a previous health center admission at a place called Falling Water. This was a very painful condition. It was a stage 4 decubitus ulcer. It was infected, went to the bone. She had osteomyelitis. While she was at Akron General, they had her on a special bed, a bariatric bed with a rotational device that took the pressure off and it replaced the need to have nursing staff manually adjust the patient. The bed did it itself. Before she was discharged from Akron General, my client, Donna Gustinski, was told that she should not go anywhere except a facility that would have that type of bed. So she had, Donna Gustinski had, done research in the area and found the defendant's facility and actually met with the admissions staff at Pleasant View Health Center prior to Marion Gustinski's admission there. And the admissions staff had promised her that they would have that type of bed available for Marion Gustinski throughout her stay at their facility. That being the case, Donna Gustinski made arrangements to have her mother transferred from Akron General Medical Center to Pleasant View Care Center, where she was admitted for approximately a month and a half. She was admitted, I'm sorry, I don't have the exact date. September 9th, she was admitted, but I don't have the exact date of discharge, but it's approximately a month and a half. During her stay, there were multiple occasions where Donna Gustinski had asked the staff, why hasn't my mother been placed on the bed yet? And she was never given a good answer till the end when the head of admissions said that he simply wasn't going to pay for the bariatric bed. So throughout her stay at Pleasant View Health Center, she did not have the bariatric bed. And what this meant for the patient was every time she would be turned, and there was an order in the chart that she'd be turned every 2 hours. It was a very painful experience for her. Marion Gustinski suffered from multiple conditions, but some of them were psychological. She had a psychosis, she had a schizophrenic disorder. So she had refused care on multiple occasions. And so this compounded the problem, and that is why a bariatric bed was even more necessary for a patient of her specific needs. We filed the complaint in this case on April 20th, 2018. On July 24th, 2018, plaintiff filed a pretrial statement, and in that pretrial statement, it listed 2 issues in the case: that Pleasant View Care Center never procured the bariatric bed as promised to Donna Gustinski, and the other one was that they staff at Pleasant View Care Center had administered a drug augmentin to which the decedent Marion Gustinski was allergic, and she suffered an allergic reaction. The plaintiff did identify Dr. Michael Hahalyak, DO, as an expert on behalf of the plaintiff. On March 1st, 2019, his report was sent to defense counsel. Dr. Hahalyak stated in his report that the decedent, Marion Gustinski, was at high risk for development of decubitus ulcers and progression of known decubitus ulcers, and how these bariatric beds with the rotational system helped in preventing the progression, and was made the patient more comfortable during the stay. And it was his opinion that the failure to provide the bariatric bed with the rotational system resulted in worsening of her decubitus ulcers. He also opined in his report that the defendant was negligent when they administered Augmentin to Marion Gustinski, and she developed an allergic reaction as a result thereof. Dr. Hahalyak's deposition was taken on September 24th, 2019, and this is where the problems begin. He said, "It's difficult for me as a physician to give a standard of care opinion on a promise." And after his deposition, defense counsel filed a motion to dismiss the case and for attorney's fees for filing basically a frivolous case. There was a hearing held by the court on December 10th, and at that time, I, as plaintiff's counsel, moved the court to file an amended complaint to include a claim for detrimental reliance or promissory estoppel, since the bed had been promised to Marion Gustinski's family prior to admission, but they failed to procure it. The court denied the motion and dismissed the case. There was a hearing for attorney's fees, but the court denied the motion for attorney's fees. We've alleged two assignments of error in this case. The first one, the trial court erred when it denied plaintiff's motion to amend the complaint. Rule 15 of the How Rules of Civil Procedure says that leave of court should be freely given when justice so requires. In this case, the defendants were aware that the bariatric bed was an issue in the case from the very beginning. It was identified in Dr. Hahalyak's report. It was identified in plaintiff's pretrial statement. The trial court had ruled that that there was prejudice to the defendant because the motion to amend the complaint was 20 months after the complaint was filed. However, it was less than 3 months after Dr. Hahalyak's deposition where this issue arose as far as whether or not he would be able to render an opinion based upon a promise. I assert that there's no prejudice to the defendant in this case, or there would have been no prejudice to the defendant, because the issue of the bariatric bed has been before the court and counsel from the onset of this case, and there was no surprise when we were moving to amend the complaint to join an issue of promissory estoppel.
Counsel, let me ask you a quick question here.
Sure.
And I may be off base, but what is this a situation where it might be interpreted as invited error or waiver by reason of the fact that you didn't 41A and refile for the promissory estoppel and detrimental reliance claims?
Are you saying that the appropriate
you could have just filed, I'm sorry, you could have just filed 41A and refiled, correct?
That's true.
All right. How does that square with the concept of waiver or invited error, since you didn't do that and the court issued a ruling?
I had a client that insisted that the case go forward as it was, and I had to follow my client's instructions, Your Honor.
Okay.
Yes, but the difference in the two is really, there's not much of a difference. If I had dismissed it and refiled it, the same issue would have been before the court. It's just a matter of, the timing associated with it from the filing of the complaint versus it would have been a new issue in the refile case where it was the same issue in the case that was already filed with the court. Again, I don't see the prejudice to the defendant in that case if either event were to occur. It's the same issue.
All right, thank you.
It's just a matter of timing.
And counsel, two things. One is, I'm not sure if you wanted to reserve any time. You have about 6 minutes left, so that you know you can reserve 5. Number 2, outside of this comment by the doctor expert regarding, I don't know how I could opine on a promise. Did the expert also opine that either in his report, his or her report, or the testimony, that the not having the bariatric bed caused additional either injury or pain and suffering to Mary?
Yes, he did indicate that both. As a matter of fact, he stated that failure to have the bed resulted in a worsening of her decubitus ulcers, but also he also indicated that there was pain associated with, the movement and turning of a patient manually as opposed to a bed doing it. Think of it as a person floating on a pillow. The bed adjusts and redistributes the pressure points to prevent the formation of decubitus ulcers, which is a lot easier on the patient than nursing staff manually turning the patient, having to grab the patient by their hands and rotating the patient. This was very painful, and the record is full of complaints of how painful it was when this patient was being repositioned. And that's one of the reasons why she refused to be repositioned, because it was so painful to her.
And counsel, one other question. What are we to do with the appellee's argument regarding the doctor expert's amount of time that he spends in the practice, whether he's competent to testify on the matters upon which he testified?
Well, he's clearly competent to testify under Rule 601. First of all, he's licensed to practice medicine in the state of Pennsylvania. And secondly, he devotes more than 50% of his professional time to the active clinical practice of medicine or its instruction. The issue raised by defense counsel, it goes to the weight of the argument, not that whether or not the doctor was competent to testify. Clearly, the doctor spends more of his time treating patients in his office, but he does have a significant patient population. He treats approximately 20 patients per month in a nursing home setting. And to say that he's not competent to testify regarding that when he's treating patients every month, 20 of them, for similar issues in a nursing home, again, goes to the weight and not necessarily the competence of the doctor to be able to testify regarding those issues.
Thank you, counsel. You have 4 minutes remaining.
I'll reserve the 4 minutes. Thank you.
Thank you. Counsel for the appellee.
May it please court. I'm Jason Ferrante. I'm here on behalf of Pleasant View. I'd like to jump in a little bit about the issues related to Dr. Hauhauyak. They kind of marry themselves as it goes through to the good faith motion. First of all, Dr. Hauhauyak spends all of his time in an office setting. He may go occasionally to a nursing home, but that certainly does not invoke any of the protections for an expert of 602. The purpose of 601 is to preclude testimony by a physician who earns a living testifying and to prevent those who lack an experiential background to the very field they seek to judge. Now, Dr. Hauhauyak could be a very fine primary care physician. He is not a wound doctor. He is not a nursing home medical director. He is not even an attending at the nursing homes. He sees his own patients, okay? And that is only 3% of his time by his own testimony. And that goes to in terms of his qualifications. Now, in terms of I want to go now to the breach of contract. A specter of prejudice arises when the plaintiff, in response to a motion to dismiss, seeks leave to amend the complaint. Those are not my words. Those are the words of this court. They came in several Ninth District courts, including Jacobson-Kirsch versus Cafferoy, which came in 2013. But it was referenced as early as most recently as March 29th, 2019 in Gasper versus Bank of America. Now, though Gasper dealt with an amendment, an attempted amendment procedurally through the filing of a motion, rather than an oral motion given within the opening moments of a oral argument on a good faith hearing. It was also referenced by the Ninth District in 2019 or 2017 in Carter versus University Park Development Corporation, where the attempt to amend the complaint was 2 years after the original filing. I reference those because we're right in the middle here, and we're still dealing with that spectra of prejudice that was not dealt with a filing to the court. It was dealt with in the very beginning moments of the oral hearing. Now, even so, even if there wasn't the spectra of prejudice that is recognized by this court, we still have an attempted breach of contract. Well, a breach of contract by a professional is in law called an action of malpractice. That was referenced in the brief in Harrell versus Crystal. I believe that dealt with more of a legal malpractice issue where there was an attempt to say that the breach of contract in some form of promissory estoppel was involved there. It's duplicative. Even if the court were to have decided, you know what, this untimely motion, I will grant it, it would have been duplicative and dismissed anyway down the road with the same arguments, that this duplication of claims against a professional, whether it be legal, whether it be medical, the breach of contract would have fallen under the medical. To the points regarding the good faith motion, I've referenced not only Dr. Hahalyak's experience, but more importantly, it's what he did over the course of a few years is looked at these records from Pleasantview on at least 2 earlier occasions and found no criticisms. If he had them, he could have put them in his reports from 2 previous forms of litigation against Falling Water that was referenced by counsel in a complaint that was filed in August of 2017. Dr. Hahalyak wrote a report. Dr. Hahalyak said he referenced those records. He reviewed them. Dr. Hahalyak had no criticisms. A second time, in February of 2018, Dr. Hahalyak issued a report in the lawsuit against Copley Health. Dr. Hahalyak reviewed those records. Dr. Hahalyak had no criticisms. It was only until we get through procedurally with those particular cases that now Dr. Hahalyak has opinions against Falling Water, or I'm sorry, against Pleasantview. And there was just some discussion about, things that were said and promises that were made. And number one, we don't know who. Number two, we don't know when. None of that was discovered and none of that is part of evidence. So unreliability and hearsay come into play with those. For that reason, I think Dr. Hahalyak did the right thing in his deposition and did testify that he can't make a standard, he can't discuss standard of care as it relates to a promise. Again, that would be determinative of whether the conversation happened, let alone whether it would be medical, anything that would be considered medical negligence. Besides the Dr. Halhalyak's issues, there was literally no discovery conducted by the appellant in this case. So what you are hearing is arguments of counsel, not evidence. And the evidence conducted by depositions from me demonstrated hearsay, unqualified experts, Dr. Halhalyak even testified that he's never issued an expert opinion in a nursing home case, long-term care case like this. He only goes to the office, and 3% of his patients, I don't think that goes to weight, that goes to competency to testify. This has always been a medical claim. It did not have a qualified expert. It did not have discovery conducted. It did not have any good faith basis to continue after that same expert looked at the records on multiple occasions and conveniently had no criticisms until those matters were either resolved or done, and then there was an opportunity to look towards this case. So in the end, I think it was appropriate for the court to find that there was no good faith basis to continue under the circumstances of the expert and the status of litigation. I also suggest very strongly that it was appropriate to not allow any amendment of the complaint on the morning of December 10th, 2019, right at the beginning of oral arguments. So I think it would be more than appropriate to recognize that there was no abuses of discretion in either of the decisions made by the court, and ask that they be upheld by this court.
How are you prejudiced if plaintiff could have 41-8 his complaint right at that moment and refiled the claims that he sought in his motion to amend?
The prejudice would have again flowed from having to deal with an unqualified expert that isn't competent to render the opinions, and that, the prejudice is having to deal with something that, if he would have 41-8'd it, I can assure you that Dr. Halhalyak is going to be the expert, and that is, he's unqualified, and it just perpetuates the litigation through an affidavit of merit from an expert that the trial court has determined is not competent to testify. If we are to look at a future hypothetical, if Dr. Halhalyak is again used, the argument would be that he does not satisfy the requirements, and that the affidavit of merit is not sufficient to support the complaint. And to be fair, any decision on whether to 41-8, that's not mine to make.
Well, you were aware of the allegation that a promise was made early on in the case, correct?
The allegation that a promise was made by only from the extent that there may have been some mention in the pleading, but as a factual allegation, not as any type of contractual breach or promissory estoppel. And at that point, there's been no evidence to explore to what extent any type of promise was made. So no, I can't necessarily agree that there was a promise.
Last question. In the notes that your client had prior to administering the augmentin, I believe it was, there was a notation that she was allergic, isn't it? And there was an opinion, I believe, that the standard of care was breached by administering the drug, despite the fact that the notes were in the record. Doesn't that provide a basis for a good faith claim?
No, not to the extent of after Dr. Hahayak testified. The reason being is Dr. Hahayak recognized that that is a physician order. The physician issued the order for the augmentin. The nurses are required to follow orders. That's why these suits arise. You either follow the orders or you don't. What we have here, though, again, is we don't have the physician who their own expert recognized issued the order for the augmentin. He had access to the same information if it was in fact there, and that physician is not a party to the case. And Dr. Hahayak acknowledged that criticism goes directly to the physician, not to the staff.
Thank you, counsel.
You done, Jason?
Yes.
Okay, I didn't want to.
Mr.
Interrupt you.
Minkowski, could you give me 1 second to reset the clock?
Sure.
Thank you. Okay, go ahead.
I'd like to pick up first on the issue of the augmentin. Dr. Hahayak agrees that the physician was negligent in giving an order for augmentin, but he also says that the nursing staff was negligent in providing the augmentin to the patient. That there's a level of responsibility. It just doesn't rest on one person. A nurse can't give a medication that she knows is wrong or should know that it's wrong to a patient. So there's responsibility on both. Although the physician wasn't joined, certainly the nursing home was, and they are the employer of the nurse that gave the medication that resulted in an allergic reaction that damaged the plaintiff. Counsel for defendant indicated we don't know who Miss Donna Gustinski spoke to. We don't know when. Clearly from Donna Gustinski's testimony or deposition, I looked up on page 111, she refers to Mr. Morris, who's the director of the facility, as a person who made the promise to provide the bed. And it was prior to the admission of Marion Gustinski to Pleasant Health Care Center. So we know both who the person was and when it was done. And it was on multiple occasions. And in the patient's record itself, there are multiple references. When is the bed going to be provided? As far as prejudice is concerned, there has been no demonstration in this case whatsoever of any prejudice to the defendant by identifying a new theory of liability, because it goes back to the very beginning of this case that we did, in a pretrial statement filed within 3 months of the complaint, raised the two issues: one, the administration of the augmentin, and two, the failure to provide the promised bed to the patient, which resulted in injury to the plaintiff. And then again, when Dr. Hayek's medical report was submitted to defense counsel, it's very clear from his report that was the main issue in the case, was the failure to provide the bariatric bed with a rhythm turn mattress, which resulted in further pain and suffering to Marion Gustinski and a progression of her decubitus ulcers. Last, I just want to mention Dr. Hahayak. If we go by what Mr. Ferranti says about he's not qualified, he shouldn't be treating patients in a nursing home if he's not qualified. He clearly is qualified to treat patients in a nursing home, despite it's a minor portion of his practice, but he's treating patients on a monthly basis in a nursing home. He's qualified to give opinions in this case. There's nothing that would prevent him from testifying because he's had the experience and he's done it for a long period of time. He's had this patient population in nursing homes that he sees on a monthly basis. Unless there are any questions, that's all I have.
Can I briefly respond very quickly?
I apologize, but that's where only the appellant is allowed to engage in rebuttal argument. But thank you both very much for your arguments today. The court will take the matter under advisement. We will issue a written decision, which will be mailed to all parties to this appeal, as well as posted on the Ohio Supreme Court website. We are adjourned until the next video oral argument, Thursday, July 8th. Thank you, gentlemen. Have a great day.
Thank you.